What's up, everybody? Welcome back into another video. Today, we're going to give an update on Brian Kohberger's case. So much has happened. The defense has filed a slew of motions. We don't have answers on them yet, but we're going to read one of those motions to suppress. That'll give us an idea. They're all pretty similar with different nuances. Then we're going to read two motions that are going to give some context to all of the motions to suppress and give us an idea of what we know and what we still don't know in this case. And then we're going to finish where the judge slams the door on the defense's request for more time and lets you know what the judge thinks about how the defense has been acting in this case as a whole, in my opinion. We're going to read between the lines and see how different of a ball game this is going to be now that we have Judge Hippler and Judge is off the case. So go ahead and hit that like button. Make sure you guys are subscribed if you have not subscribed already. Let's get into it. All right, so the first thing I did want to show you guys is what the docket looks like since November 13th, basically. The defendant files a sixth motion to compel. Defendant asks for more discovery. The defendant lists his exhibit list, and they talk about the grounds of arbitrariness for the death penalty. The defendant files a motion for leave for more time to go through discovery and to ask for discovery and produce discovery, a discovery extension. We're going to read this motion for leave to discuss what it means, and we're going to read the order denying it as well. That's going to be what we do at the end of the video. There's a motion for a Franks hearing. We know if you followed Richard Allen's case, what a Franks hearing is. We're going to read through that motion. And then there's a motion to suppress the genetic info. And we know that the genetic genealogy in this case, the IgG, is a huge part of this case. And some have been saying it is the most important connection or piece of evidence that the state has in this case. Well, the defense wants to suppress it, wants to keep it out. So we're going to read that motion. And then there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 more motions to suppress. Now, some lawyers make one motion to suppress and they put all the evidence they want to suppress. They could have listed all 12 things. The lawyers for Brian Kohberger decided to do it in 12 different motions. We are going to read one of them, but I just want to kind of give you an idea of what they're trying to suppress, which is basically everything, right? The genetic info, and then this is an issue with the warrant. And we're going to hear about these two motions referenced in the motion to suppress that we read, but they want to suppress the Amazon info, apartment search, Apple, arrest warrant, AT&T first warrant, the cell phone data, the Google data that they got, the pen trap trace device, the person in the ID, the person in PA, or in Idaho, person in PA, the white Hyundai, and statements, okay? So there's all sorts of things that they're trying to suppress. They use some very similar arguments throughout, which is why we're just going to read one, because it gives us insight into exactly what the defense is trying to do, but also what we really don't know about this case, and that is not going to change today, okay? So I'm going to remove that, and again, if I had time, I would go through all of these motions to suppress. I don't have time to do that today, but I think you're going to get the idea when we go through this first motion to suppress and kind of see how this works. So this is the Amazon account information from the grand jury subpoena. Comes now Brian Kohberger by and through his attorneys of record and submits the following memorandum in support of his contemporaneously filed motion for an order suppressing all data found by law enforcement from its search of his Amazon.com account. And a lot of the other ones, Google and other things, very similar language. The motion and documents in support. So here's the first reference that we're going to read in the other motions. The motion and documents in support of a Franks v. Delaware hearing are hereby incorporated into this memorandum. The proffer with supportive documentation regarding Franks are filed under seal. For that reason, they're not set forth in full detail here, but instead are incorporated. So what this means is there are going to be things referenced in all these motions. There's going to be context in all these motions. There's going to be specifics in all these motions that we don't know, that we don't have, that are still under seal. So it is very, very difficult to kind of come to a conclusion here, a legal conclusion, because I know there's information we don't have. And there's so much information in a case, and there's so many answers in the law that are, it depends, that when you know that you don't have all the information, it is very, very hard to give a full answer. But here are the issues, and they set it out like this in all the motions. They're set up very similarly. Kohberger has a privacy interest in his Amazon.com account information protected by Article 1, Section 17 of the Idaho Constitution and Fourth Amendment, requiring information that requires a warrant. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Remember this, we're going to talk about it later. The affidavit in support of the application for the issued search warrant included information that must be excised. When you have a search warrant and you screw it up, there are a couple different ways to deal with it. You can either throw out the whole search warrant, suppress everything, fruit of the poisonous tree. If it's a bad search warrant, then all the evidence you get, you throw out. Or if there are just portions of the search warrant that are wrong, you see if you can remove that portion and if there's still enough probable cause to go forward and gather the evidence that you have probable cause to gather. All information in the affidavit was gathered because of law enforcement's unconstitutional use of IgG, investigative genetic genealogy, and thus nothing in the warrant should remain. Information gathered about Mr. Kohberger via previous invalid warrants must also be excised. So this is a first reference. There's going to be more references to the IgG and how what they did here was unconstitutional. And this goes back to now a lot of this was filed under seal, but if you look at information from prior hearings that we've watched and from prior filings that we've watched that haven't been under seal, you know that the defense is saying they basically worked backwards. They got Kohberger's information, went and potentially accessed databases they shouldn't have accessed, got his information. That's how they were putting the case together for Kohberger, and they focused on Kohberger. They didn't use it to cast a broad net and kind of find their answer. Okay. People are asking to enlarge the document. Okay. Listen, if you can't read it, don't worry. I'm going to read every word. I do my best always to make it. Sometimes they come off a little bit blurry. I enlarge it as much as I can for it to still be on the screen appropriately. So John asked, wonder what he purchased from Amazon. That may be important. So John, that may be important, or it may be nothing. And the defense is saying you're going to make it seem like it's something, but it's not. Or it could be the weapon. It could be the sheath. It could be the clothing that was worn that night. It could be masks. It could be a million things, right? But the point is, they are saying that regardless of how relevant or even damning what he bought on Amazon was, they can't use it because the way they searched it and the way they got that information is improper. And this is potentially putting to the test. Let's say he ordered the weapon he used that night, a knife, on Amazon, and we have proof, we have the receipt. But let's say law enforcement violated his constitutional rights by getting his Amazon information, getting his DNA, and finding and searching all of this stuff. How many people in the chat are going to be okay with throwing out a purchase of the weapon that was used? That is the ultimate question as to, do we want to protect our constitutional rights? I hate it. I would hate if that was the case. I would absolutely hate it. It would feel like no justice anywhere, but it would be the fault of law enforcement if they really are violating people's constitutional rights. Let's hope that's not the case here. Let's hope that's not what's found. Let's hope everything was done appropriately, especially if it was the weapon. I don't think that's what it is. It doesn't seem like that's what it is. I know some people think that that is what it is and there are receipts for that weapon. I don't think that's the case, but generally speaking, I would hate it if that was the case, if law enforcement is stepping on someone's constitutional rights, even if they got something important, because I would have to be on the side of it's got to be suppressed, because we have to uphold the Constitution even for the worst of us, even in the worst situations, or it's not going to work for the best of us. I know there's going to be people that don't like that, but it is what it is. And I'm not saying that's what we have here. Okay. So yes, I agree with that, Jana. Let's pray that isn't the case. Let's pray that law enforcement did everything above board and were appropriate in everything. Thank you, Stella by the Sea. All right, let's read some of the facts in this motion. Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's parents' home on December 30th, 2022, and arrested him. At some point, the FBI subpoenaed the Amazon records belonging to Mr. Kohberger's account. On December 30th and January 27th, Amazon responded with the records showing Mr. Kohberger's purchases. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the Idaho Constitution, on April 26th, Detective Maury of the Moscow Police Department requested a warrant for the same information, telling the court that an unnamed FBI special agent had located requested information. The warrant was amended due to the date error and ultimately issued on May 8th, 2023. The affidavit for warrant was signed by Detective Mowry, Exhibit A. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. But according to Mowry, now the sworn statement of Corporal Payne. Very confusing. And usually when law enforcement goes back and does something again, it is because they feel like they screwed up the first time. Sometimes. So there is a defense to the fruit of the poisonous tree and to stepping on someone's constitutional rights. And it is known as inevitable discovery. So let me give you an answer. All right, let me give you an example. If the officers have enough for an arrest and they search the car incident to arrest, and maybe they search some areas they shouldn't because they're looking for, I don't know, a bazooka, and they search the glove box or something like that they wouldn't really need to search. And they arrest the defendant, they impound his car. Well, if they did an illegal search at the scene where they arrested the defendant and there was anything that was illegal about that search, they were going to impound his car. And when you impound your search, you do an inventory, or impound your car, you do an inventory, and they would have searched all those different compartments. So inevitably, they would have discovered whatever it is that they discovered, maybe some drugs or something in the glove box. So if something was going to happen in the process appropriately, where law enforcement was inevitably going to discover something, even if they didn't do whatever the screw up was that they did first, then it can still be admissible and they can still use that evidence because inevitably they would have discovered it. Maybe that's what happens here. Maybe not. I don't know. Because again, the exhibit, we're not able to look at, we're not able to, investigate, really dig into to see what we think is going to happen. Now, I do think there's going to be a hearing on this in January, I believe it is. I don't know if this is a December or January hearing. We'll see how much of it is done in front of the cameras. All right. Basic facts Mowry used to support the search beyond the arrest warrant facts were very minimal. A vague reference that an FBI special agent located an account for Kohberger, Amazon provided order history records regarding customer email and his email. How the agent located that was not explained. Investigators know that Amazon holds records for identifying devices the customers use to access their account. All linked accounts, other items customers have searched, clicked on to, placed in the cart to be viewed and saved. Who or how the investigators know this is not explained. Little information about how Amazon collects and holds data was explained. The time frame of March 20th through March 30th of 2022 and November 1st through December 6th were selected. And now here's the defense's argument. Kohberger has a privacy interest in his Amazon.com account information protected by Article 1, Section 17 of the Idaho Constitution that requires a warrant. Both the federal amendment and Article 1, Section 17 protect people's interest in privacy. A person challenging a search has the burden of showing that he or she had a legitimate expectation of privacy in the item or place searched. So again, different nuances of this very similar argument were made for everything that they're trying to suppress, including the search of his mother's home or his parents' home, right? Some people were trying to argue, he doesn't have an expectation of privacy because it's not his home. He doesn't have standing to challenge that search. That's wrong. Courts have found that I believe even overnight guests have an expectation of privacy in the home that they're staying in. You can't just bang down the door and search the house without a warrant. Okay, in this case, they had a warrant. Now, whether or not they should have knocked is another argument I think the defense is going to make. But let's continue to read here. That involves a two-part inquiry. Did the person have a subjective expectation of privacy in the object of the challenge search? And is society willing to recognize that expectation as reasonable? So in this case, when we're dealing with the Amazon information, do we expect those purchases to be private? I think most of us can say yes. Anything you log into with a password and a username that you're making that you don't think other people can see. And this doesn't mean that Amazon, the company, of course, can see it. But generally speaking, I think we have an expectation of privacy. Now, I think we also know that if we get arrested and they get a warrant, they can order this from Amazon and they're tracking all of this. But it doesn't mean we don't have an expectation of privacy in what we're doing. Just like in our house, we have an expectation of privacy. That's very different than if we do something on the sidewalk or on a public road. Same thing here. If I purchase something here, it's different than maybe Venmo, where you click, where you send money back and forth. Is that public or is that private? And in Amazon, it's not public what everybody buys on Amazon. Would be kind of hilarious. I feel like you'd get to know people if you could see what they ordered on Amazon. I don't think you could keep up with all the boxes that show up at our house. I don't even know. It's every day something new is on my doorstep, and none of it's for me, unfortunately. The Fourth Amendment has generally refused to acknowledge that individuals have a privacy interest in records held by a bank relying on third-party doctrine. This despite the fact that law has required such records to be maintained for the purpose of criminal investigations. Unsurprisingly, the federal Congress responded negatively. As this court is no doubt aware, the third-party doctrine holds that information shared with anyone with whom the person does not have a recognized evidentiary privilege is free for the government to take without a warrant. To put it another way, the third-party doctrine insists as a matter of law that you should trust your secrets to no one. Idaho has taken a somewhat unclear approach to third-party doctrine. The court permitted protected health records to be provided to the government. In State versus Close, the court did the same for the billing statements from a utility company. In State versus Donato, the court held that people had no expectation of privacy and trash placed out for pickup. However, the court also held in State versus Thompson that under the Idaho Constitution, citizens do have a right to privacy in what they call and later extended to text messages. Idaho is not the only jurisdiction to have trouble with third-party doctrine. The United States Supreme Court has refused to apply it to both the search of cell phones and the use of cell sites. The issues the United States Supreme Court seemed to take with third-party doctrine in its most recent decision seem to be the scope of the information available to the government without a warrant if one follows it closely. This concern was first fully anticipated by Justice Sotomayor in the concurrence opinion in U.S. versus Jones. It is difficult to square this concern with what the court decided in Miller, because as the third-party doctrine defender, Professor Kerr, puts it, in Miller, the checking account was created a substitution effect by replacing a transaction that would have included substantial public components with a transaction that would normally occur entirely in private. To see how, imagine a world without banks. If you need to pay for something in this world, you would need to get money to do it. You would need to travel to your stash, pick up the money, and then travel to the place where you're making your purchase. If you are the seller, you need to receive the money, take it back to your stash, store it away for safekeeping. There are public parts of the transaction on both sides. Checks and other credit instruments eliminate the need to travel. The buyer no longer needs to travel to bring the money to the seller, and the seller no longer needs to travel to put the money away. Instead, the seller deposits the check and the funds into a bank and are sent directly to him. The buyer and seller don't have to move anymore as the check moves the funds out of and into their accounts without them needing to go anywhere. The third party of the checking account makes the entire economic transaction private. In other words, as Professor Kerr argues, Miller makes public precisely the amount of information Carpenter held private. No doubt, the fact that our economy has changed greatly since the 1970s has a part to play in this. But the fact remains that the Miller case and its progeny make little sense in today's world and are irreconcilable with the court's current jurisprudence. So it is interesting just to kind of think about the difference between, like, if I were to go to Walmart and buy something and they want to go search the Walmart records because they see me on the camera in Walmart and that's a public place, versus Amazon, which I'm doing in the privacy of my own home. So I think I have an expectation of privacy, but I can kind of understand the arguments for both sides, right? And the case law is kind of mixed here. So that's why it's going to be based on the judge's decision. But the defense searched it and then later got a search warrant. So will they have that inevitable discovery argument? I'm sorry, the state. The state, got those records, but then later got a warrant for it. So are they going to have that inevitable discovery argument to the judge? And what is the judge going to end up deciding? That is all kind of up as we are changing with the times. When I sit in the civil rules meetings right now in Florida and we're writing rules and editing rules, and when we make these changes, so many of the changes have to do with technological updates. The law is always so far behind because it takes us so many years to correct the law and go through all the processes. So where is the expectation of privacy? And from my perspective, it is something that is still updating. So yeah, Trauger kind of asked this question. Yeah, that's what I'm going through right now. And these are the arguments we're making to the court, and the court's going to have to make these decisions. If you're doing something in a public place, that's very different than ordering it in the privacy of your own home. And the public can't see what I order on Amazon. I expect it to be private. I think some people, that order maybe hair dye, or they order, I don't know, eyelashes or whatever, stuff that they try to pull off as real or true, or them, wouldn't want people to know. And they order it through Amazon, and it's kind of like in the movies where they go and, on prom night, they got to go order something that they find to be embarrassing, or buy it at Walgreens, or they go buy female products for their wife at CVS. And it's like, oh, you got to walk through the line and whatever. All that's pretty much taken out because it's not public anymore. It's private, right? That's the way I look at it. I don't know if that's where the law is going to end up, right? But that's the way I look at it. If you're putting in a password, if you're not sharing things publicly, I think you have an expectation of privacy, but we'll see. Okay. In Idaho, on the other hand, the court in Thompson determined with relatively little analysis that Idahoans expected privacy beyond that which the United States Supreme Court had provided for the people they call. In essence, the court, without much explanation, held that the dissent in Smith had it right. However, it remains that by adopting the dissent from Smith, the Thompson court adopted a rationale for rejecting the third-party doctrine. From Justice Stewart's dissent, Idaho adopted the notion that what a person does in private does not become public merely with the nature of the act. In my view, this is from the case. Whether privacy expectations are legitimate within the meaning of Katz depends not on the risks an individual can be presumed to accept when imparting information to third parties, but on the risks he should be forced to assume in a free and open society. By its terms, the constitutional prohibition of unreasonable searches and seizures assigns to the judiciary some prospective responsibility. As Mr. Justice Harlan, who formulated the standard the court applies today, himself recognized, since it is the task of the law to form and project, as well as mirror and reflect, we should not merely recite risks without examining the desirability of saddling them on society. In making this assessment, courts must evaluate the intrinsic character of investigative practices with reference to the basic values underlying the Fourth Amendment. And for those extensive intrusions that significantly jeopardize individuals' sense of security, more than self-restraint by law enforcement officials is required. So what I'll say, by the way, just because I'm saying, hey, I think we have an expectation of privacy, et cetera, et cetera. People are saying not buying hair dye is not embarrassing. I don't know. I don't know what it is that people, I don't dye my hair. I have gray. Okay. I have gray in my beard. But just because you have an expectation of privacy, okay, so here's the very important part too. Does not mean law enforcement can't get a warrant and go get your Amazon purchases. It's just, can they get it without a warrant? Can they just request it or subpoena it? Very different than having a warrant to get something. And that's where we're at, right? A warrant, you need to have probable cause that this person committed a crime and you need this information to help you build that case. So that's more than just sending a subpoena because something might be relevant here. And that's the question, is what can you buy? What can't you buy? I just said buy. What can you get? What can you not get? Despite this, in Donato, the court rejected Justice Marshall's dissent in California v. Greenwood. All the same, the court did not simply join the Greenwood majority. Instead, the court took the middle path set out in Colorado decision People v. Hillman. That decision noted distinctions between garbage and telephone calls in that the latter are open to the public and carry duties of confidentiality, while the former do not. As our Supreme Court noted clearly, there is no duty of confidentiality owed by garbage handlers. Including in the analysis, however, is that Colorado had rejected not only pen registers, but that bank records should be obtainable without a warrant. The Colorado court found that their cases recognizing expectation of privacy in numbers dialed from the telephone on bank records. This brings us to Mubita. The court in Mubita adopted Miller, finding without explanation that in Idaho's jurisprudence would support a divergence. Although the court in Mubita analyzes both Donato and Thompson, the court makes no mention of their rationales and instead differentiates them based on whether there can be a finding of greater protection exists due to the uniqueness of our state, our Constitution, and our longstanding jurisprudence. This holding ignores the holdings in both cases to craft a new one. That should have required the Mubita court to reject Miller, given the longstanding jurisprudence of the only two cases on point in their holdings rejected the simplicity of the third-party doctrine embodied by the Miller holding. So just in case you feel like you're getting lost in some of this, this is the defense trying to make a good argument when the case law in Idaho does not seem to be in their favor. Instead, the court in Mubita looked at the Court of Appeals decision about utility bills, and once again, the court ignored the actual rationale of the holding in Cluse, merely noting that it also applied to Miller to Billings. In reality, the court in Cluse did no such thing. In Cluse, the court simply adopted the ruling that the district court in the case That holding, which it adopted, did not simply apply Miller. Instead, the district court had rejected the reasoning of California and Washington cases on the grounds that power usage did not provide any intimate details of Cluse's life, identifying his friends or political or business associates, nor did it provide a complete virtual current biography. Finally, the Mubita court notes that one's HIV status is heavily regulated via state and regulation and may be disclosed to protect the public. This part of the court's decision, although treated as almost an afterthought, provides the reasoning in the case as to why the defendant could not show a privacy right under Article 1, Section 17. After all, if the confidentiality of the information had a disclosure requirement built in, it was necessarily different from the phone records. Phone records would not, on the face of them, alert the company to a threat to society. Diseases are different. Thus, although the Mobita court held that Miller controlled every aspect of the decision, belies that holding, means like disagrees with that holding. Idaho's constitutional exclusionary rule, unlike the federal constitution, protects privacy. So they're saying Idaho goes a step further than the Constitution. Given the rationales in the holdings of all the cases, even Mobita, Miller has no place in Idaho. There's even some interesting legal discussion that we're not going to get into, like the search of Kohberger's parents' house that happened in, was it Indiana, I think? Was it Indiana? I can't remember. But they were saying which law should apply, Idaho or Indiana, and some interesting legal discussion there as well. This case is not about bank records, but purchase records from an online company. From the standpoint of the Fourth Amendment, one's behavior on Amazon can provide a massive amount of information about a person's life. I was like, am I missing something? Your name, address, searches, and records. When you speak to the Alexa voice assistant, it knows your orders, content you watch on Prime, your contacts if you upload them, and communications with it via email. Meanwhile, you use its website, cookie trackers, and are used to enhance your shopping experience and improve its services, Amazon says. Some of the data is used for personalization. Big tech speaks for using your data to improve your online experience. Oh, it would have been perfect for a sponsor I have coming up in a video soon, with all of your data being gathered everywhere. Some of the data is used personal. Okay, so I already said, can reveal a lot about you. For example, if you just use it online for the retail site via the app or website, Amazon will collect data such as purchase dates and payment and delivery information. From this information, Amazon can work, where you live, know how you spend your leisure time, and who your family and friends are, says Rowena Fielding, director of data protection consultancy, Miss IG Geek. So basically what they're doing is they're basically trying to say, getting somebody's Amazon information, Pennsylvania. Sorry, my B. Not Indiana, Pennsylvania. So they're basically trying to say, if you get the Amazon information, you get everything. You get everything about this person, and you have an expectation of privacy when it comes to all of this information, your address, what you order, when you order it, who you talk to, what you say to Alexa, what you watch on Amazon Prime, et cetera, et cetera. At the same time, Prime Video and Fire TV information about what you watch and listen to can reveal your politics, religion, culture, and economic status, says Fielding. If you use Amazon to store photos, a facial recognition feature is enabled by default. Amazon promises not to share facial recognition data with third parties, but it makes no such commitment about other types of photo data, such as geolocation tags, device information, or attributes of people and objects featured in images. So this is something that is an argument in favor of the state. It's like, there are certain things that, they say we're not going to share with third parties, and other things that they don't say that about. So if they don't say that about it, should you know they're going to share it with third parties? Amazon Photos does not sell customer information and data to third parties or use content for ad targeting. An Amazon spokesperson says insisting the feature is for ease of use. You also have the option to turn the feature off in the Amazon Photos app or the website. Meanwhile, Amazon's Kindle e-reader will collect data such as what you read, when, how fast you read, what you've highlighted in books. This could reveal a lot about your thoughts, feelings, preferences, and beliefs, says Fielding, pointing out that how often you look up words might indicate how literate you are in a certain language. Smart speakers have been criticized by privacy advocates and devices such as Amazon Echo have been known to activate accidentally, but Amazon says its Echo devices are designed to record as little audio as possible. Ooh, it's scary to think about all this. No audio is stored or sent to the cloud unless the device detects the wake word and the audio system is closed immediately after a request is ended. An Amazon spokesperson says. More broadly, Amazon says much of the information it collects is needed to keep the products working properly. An Amazon spokesperson says the company is thoughtful about the information we collect, but it can add up to a lot of data. In 2020, a BBC investigation showed how every motion detected by its Ring doorbells and each interaction with the app is stored, including the model of phone or tablet and mobile network used. Ring can share your stored data with law enforcement if you give your consent or if a warrant is issued. So that language, I don't know if they pulled that specifically from Amazon's website. Interesting there. They pulled it from some articles, it seems like. Whoa, what just happened there? That was weird. I don't know what just happened. It went to guarding your website. Hold on. Let me pull this up again here. Oh, I think I clicked that. I think I may have clicked that link. That's probably what happened. You know, sometimes with these Apple, this Apple mouse, they have these shortcuts on them, and I don't even know how to use them. But I think I just clicked that link. All right. For these reasons, the court. Wait, did I? It's not garbage one leaves on the street where snoops can find it, nor is it HIV information that society has a stake in knowing. For these reasons, this court should find a warrant is required to access such information. Thus, the FBI subpoena gathering the information from Mr. Kohberger's account violated his rights, and its results must be suppressed. So that'll be kind of the big reason and decision that the judge is going to have to make. MMECAT. It's like the scary thoughts, right? Scary thoughts. The state said they were filing a motion to suppress the IGG, not just the defense. The state doesn't want the IGG either. I think the state might not want some of the background stuff with the IGG, but DB, you could be right. And there's so much going on in this situation that we don't know behind the scenes under seal that it's really hard for me to even try to begin to guess what's going to happen with the IGG. Would the Amazon data technically belong to Amazon? Technically, yes, I guess. And that's why you can subpoena it from Amazon and not from Brian Kohberger. CJ, isn't it interesting how the new judge is responding? I wonder if the defense is realizing that the grass is not always greener in the other county. I have heard rumblings. I don't know if this is true. Maybe the chat can confirm. I heard Judge is retiring. Is that true? Can Amazon release it as a private company? If police said we're looking for someone in that area that made a certain purchase. So that's kind of the rub here, right? Is how much can my expectation of privacy be pushed on a third party? If I give that third party my information, how much can I stop them from sharing it? I think I have a reasonable expectation of privacy. But if they put in the fine print that they're going to share it with third parties like we just read, it's a tough argument, right? If you're talking about, I don't know, if you're trying to get somebody's glasses prescription from Walgreens because it was a car accident, they say they weren't wearing glasses and you have some reason to believe they did. Can you go get that? Or is that private information? So generally speaking, usually you can subpoena records from third parties. Like they were talking about banks, like they're talking about even like your trash, because you're like, once it's on the garbage truck, like what's to stop the garbage man from going through it, right? They're not supposed to, but there's a lot of conversations about expectation of privacy and unlawful search and seizures. And I always like to think of my expectation of privacy as I think I have a much larger expectation of privacy than, legally speaking, what we end up having in a lot of how the cases turn out. Lauren, laid up after wrist surgery today. Thanks for helping me make the recovery time educational and informative. Lauren, pumped you're here. Glad you're here, hanging out with us, learning, and seeing what we think is going to happen in the Kohberger case. All right, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. This is Frank's hearing or Frank's motion language. The Fourth Amendment states unambiguously, no warrants shall issue, but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. Probable cause exists when, given all the circumstances set forth in the affidavit, there is a fair probability that contraband or evidence of a crime will be found in a particular case. For a search warrant to be valid, the judge issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath and recorded that establish the grounds for issuing a warrant. Any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppression. It is clear that the issuing magistrate himself, if he is to fulfill the constitutionally demanded function of interposing an independent intelligence between the law enforcement officer and the citizen, must actually and in fact draw the inferences from the evidence presented to him. It is for this reason that the courts have insisted that the full facts from which the inferences might be drawn and information necessary to determine their reliability be placed before the issuing magistrate. Finally, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant. Upon a preliminary showing of a warrant deficiency, the defendant must prove by a preponderance of the evidence that intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. An omission of exculpatory facts is material only if there is a substantial probability that had the omitted information been presented, it would have altered the magistrate's decision to grant probable cause. Whether an omission is intentional or reckless might be inferred in part from the relative importance of the information and its exculpatory power. So right here is the big question, right? And this all sounds really great. And all of this is correct, right? They're laying the foundation for the argument they're making. But it's only material if the information either being included or that was omitted, if you change that, if you take out information that was just wrong and they shouldn't have put in, or if you put in the information they absolutely should have put in but they didn't, it has to have, basically you got to be sure that it was going to change the magistrate's decision. Substantial probability that it would have altered the magistrate's determination of probable cause. That's the big question. So guess what? Let's hear what law enforcement screwed up. What did they put in or what did they keep out, right? So Ashley, no, not everybody can just go get it, but you can subpoena that. Certain people can subpoena it just like law enforcement did in this case. I'd have to look. Every jurisdiction's a little bit different, right? But there are definitely documents you can go get, like people's cell phone records, for example. You would think that would be private, but you can subpoena that. You don't need a search warrant necessarily to get that. In like a civil case, for example, you can get that. But it's all a little bit different in different jurisdictions. In criminal cases, civil cases, it's all a little bit different. But no, I can't just go see your Amazon activity for no reason. There has to be a legal reason for it. All right. In this case, law enforcement either intentionally or recklessly omitted exculpatory evidence as to almost every facet of its affidavit for this warrant. Oh, great. Let's read what they did. Thus, it will require suppression. But the proffer required for a Frank's hearing is filed contemporaneously under seal. The proffer asserted applies here. In addition to the proffer, the affidavit for the Amazon search warrant did not explain to the magistrate that federal agents had been talking to Amazon and issuing subpoenas, and that was how they gathered information for the affidavit. So they're basically saying they did it backwards. They got information from Amazon, then they used that to prove probable cause to get the warrant, and that's how they went back to get the information, and that's no good. Mowry intentionally failed. Mowry intentionally failed to disclose the illegal means by which investigators had located the Amazon information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. Where information in a warrant was obtained via violation of the Constitution, Idaho courts excise that information. All information in the affidavit was gathered because of law enforcement's unconstitutional use of the IGG, and thus nothing in the warrant should remain. So they're like, okay, there's 25 paragraphs in this. Let's excise. Let's cut some of these paragraphs. Okay, which paragraphs do you want to cut? I want to cut paragraphs 1 through 25. Mr. Kohberger has argued in a separate motion that genetic genealogy investigation in this matter was done in violation of the Constitution. We're going to read that in a second. Additionally, he argues there would be no investigation into him without that original constitutional violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to this case was his mode of transportation, that he drove that white Hyundai, and the shape of his eyebrows. That's what they're saying, right? This is bold language by the defense. The only thing that connected him to this case was the car he drove, which thousands of other people drove, and bushy eyebrows, which millions of people probably have bushy eyebrows. Two identifications of little to no value. As the Idaho Supreme Court has explained, while the initial burden in showing the factual nexus between the illegality and the evidence, the state must show it would have been discovered anyways. That's inevitable discovery. The state cannot make this showing. Without the IGG, there is no case. No request for his phone records, surveillance of his parents' home, no DNA taken from the garbage on the driveway in a gated community under a garbage collection ordinance. See, again, everywhere has a little bit different rules. Because the IGG analysis is the origin of this matter, everything in the affidavit should be excised. Information gathered about Kohberger via previous invalid search warrants must also be excised. Separately, information gathered various other search warrants will be excised. The reasons set out in other motions to suppress. And the conclusion. Mr. Kohberger requests this court suppress all evidence obtained by police via the subpoena and warrants that permitted them to search his Amazon account. As explained above, a warrant was required to search his account, and the warrants used lacked probable cause as written, given its heavy reliance on the conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions, and because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, and finally, because the affidavit relied on evidence gained in violation of the Constitution, all in violation of the Fourth Amendment and Article 1, Section 17. Okay? Whew. Okay, that was a lot. I'm going to take a deep breath here. So let's take a look here real quick at two short motions. And these were the motions referenced in that prior motion to suppress. Comes now, Brian Kohberger, through his attorneys of record, and moves to suppress all evidence illegally gathered by law enforcement using his genetic information. This motion is made pursuant to the Fourth Amendment of the United States Constitution. A memorandum and exhibits, which is the actual information we need, are filed contemporaneously in support under seal. This motion is being filed under seal pursuant to Honorable Judge's previous order stating that pleadings related to this motion be filed under seal until the court could review the issues and arguments filed. The under seal memorandum and exhibits are being provided to opposing counsel and court staff via email on the date of this motion. Hand delivery to the court for in-person filing will occur no later than November 18th. Now let's take a look at the Franks motion. Comes now Brian C. Kohberger, Brian through his attorney of record, moves the court to conduct a Franks hearing. This motion is made pursuant to the Fourth Amendment of the United States Constitution and the Idaho Constitution and Franks v. Delaware. A proffer and exhibits are filed contemporaneously. The parties stipulate to sealing the proffer and the exhibit. Parties agree, so it's being filed under seal, provided to counsel, hand delivered to the court November 18th. So the really important stuff, what do they have? What lies were told? What important exculpatory information was left out of these search warrants? We don't know. And that's the bulk of the argument. And that's why hopefully in the hearing, because there is the opportunity, the way that it's written right now, the judge can look at this stuff, can look at the motions under seal, can make a decision that some of this stuff can be public. We don't have to seal it, or we can argue it open in front of the cameras in open court. The judge can still make that decision after reviewing the evidence and the motions that are filed under seal. So that's something that we're going to have to wait and see. All right. Now this part. This was perhaps the most interesting exchange that I read. And I'm being honest, right? This is not hyperbolic. I'm not blowing smoke. Legitimately, as a lawyer who's had cases switch judges, and you file a motion, okay, the defense's head, right? They have filed a lot of motions to extend deadlines, to continue the case, to ask for more time, to complain to the judge that there's just way too much discovery, to say they need certain things filed under seal, then later to say they need things that need them to be unsealed, right? They're fighting hard for their client, which I do love to see a defense attorney fighting hard for their client. But they were getting their way with basically everything. They were winning basically every time they made those complaints. And I agreed with a lot of that, right? To have something done in 6 months, that's tough, right? There's a lot of evidence, but it's been 2 years now. It's been 2 years. This is not the most complex case in the history of cases, okay? I will just tell you that. There have been way more complicated cases than this case. And there will be more complicated cases in the future. 2 years with the amount of resources and lawyers and time and money they're putting into this case, that is enough time to go through this. Now, unless they can prove the state withheld discovery past their deadline and gave it to them late and they didn't have time to review the new discovery, open to those arguments. But every time they've asked for an extension, every time they've asked for a continuance, every time they've asked for something to be sealed or unsealed, it seems like they win the vast majority of those arguments. We have to be careful not to step on a defendant's right to a fair trial, not to push a defendant or force a defendant. Remember, this is the same defendant that demanded a speedy trial at the beginning of the case. So let's read this motion. Comes now Brian Kohberger, buying through his attorney of record, and hereby moves the court for leave from this court's order governing further criminal proceedings and notice of trial setting specifically the discovery motions deadline of November 14th, 2024. That would be those motions to suppress that we just read. Defense counsel and investigators have not had finished a full review of the vast amount of discovery in this case and will continue to do so. There's just so much in this case, Judge. Counsel requests that this motion be set for hearing in order to present oral argument, evidence, and testimony in support thereof. So here's what I'll say. This is such a bare bones motion, it almost sounds like they expect the judge to grant it. And why might they expect that? Because that's kind of how it's gone in this case. But to be fair to the defense, they did say, can we have an oral argument, Judge, so we can explain to you why we need more time? Because if there's a legitimate reason, they should explain it. Now, here's what I would say. And I also think that maybe the defense will do this in the future now with Judge Hippler, because it's not Judge anymore, and these motions are not going to get rubber stamped. They should have taken some time and put the information into this motion. We talked to our investigators, Judge. He has been through, 2.8 of the 3 terabytes. So we only need 0.2 terabytes to go through. We need 1 extra month. Like, put what you actually need, what the problem is, how we can solve it, give the judge an idea, as opposed to, we need more time, let's have a hearing. And when did they file this? November 13th, to extend a deadline that's on November 14th. So if you watched the Judge Hippler hearing, no surprise, he doesn't seem like a man that enjoys things like that. Let's take a read. So here is the judge's order denying this motion and slamming the defense, or slamming the door on the defense. It is a different ballgame now under this judge, no doubt about it, in my mind. I will just tell you. And I've had cases that have felt like completely different cases once the judge changed. Before the court is defendant's naked motion for leave. Okay, so in the very first line from this judge, judges have different ways of doing things. And they can be softer or kinder or gentler, or they can be a little harsher. This to me was intentionally harsh for the judge, letting the defense know this is not how we do things in my courtroom. This is not going to fly. Before me is this naked motion for leave on November 13th, in which the defendant seeks relief from the discovery motions deadline of November 14th, as set forth in the governing scheduling order. The defendant asserts his counsel and investigators are still reviewing, quote unquote, the vast amount of discovery in this case, and therefore he needs additional time to file motions related to discovery. And the footnote is just order governing the further criminal proceedings and notice of trial. This order does not foreclose discovery motions pertaining to new or supplemental discovery responses, or in the event new information comes to light requiring additional discovery motions. So he's saying, he's putting here in this footnote, I already told you if there's something new or some reason you need to file additional motions, we can do that. But you got to tell me what the new information is. You can't just say, I need more time unilaterally, and for me to just say, yes, okay, take as much time as you need. We've got to have deadlines. We've got to do things within those deadlines. We've got to have a schedule. We've got to have a calendar. Motions to enlarge a deadline filed on the eve of that deadline are not well taken, meaning the court does not like that way of doing business. The state's discovery deadline was September 6th. The defendant could have ascertained far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention. So he's saying they were supposed to give you everything on September 6th. What was that, 2 months ago? So if they gave you 50 terabytes of documents, I'm just making that up, or of information, of digital information. If they gave you 50 terabytes and you look at this and you're like, it's impossible for us to go through all this, you should have filed your motion to extend it at that time. Now, if I'm the defense, my response would be, Judge, we did our best to try and get through it all in these 2 months, and we didn't know we were unable to until the eve of the deadline. We did our best in candor with the court to do the best we could with the court, with the time the court gave, and we just couldn't do it, Judge. I don't know what else to tell you. And if they make that argument, I would be okay if they prove to the judge that they did everything they could and they couldn't get it done in time to extend the deadline. That's the point of how all this works. And especially if it comes to doing with if it comes to do with the discovery that was filed on September 6th, the newer discovery. It's like, okay, we get it. It's all brand new, Judge. We couldn't get through all the new stuff. So please, can you give us more time? And I think the judge would have given it to him if they would have just explained the reasons why. But the way they did it is, I think, the biggest problem the judge had. Not that they're asking for more time. I think the judge will grant more time in this case if it's necessary for either side. I think he's going to be fair with that. I don't think he's going to like make it so impossibly difficult for either side. But I don't think he likes it just saying, hey, can you give me this just because? Or because I said so, or because I asked for it. Further and importantly, the defendant has not demonstrated with his filing good cause to enlarge the deadline. Give the court good cause. If you give me good cause, then maybe I'll grant it. He has not set forth what efforts have been made to review the discovery, what portion of the discovery has not been reviewed, why it has not been reviewed, or how long it will take to complete it. That's the biggest thing. It's like, tell me what you need. Do you need a week? Do you need 3 days? If it would have been like, Judge, we need 3 days, we need till next Monday, I'm sure the judge would have said yes. I'm sure the judge would have said yes. But they didn't. They're just like, we need it. We're asking for it on the last day. Let's set a hearing a month from now. It's like, so what's going to happen in that time between now and when we send the hearing? Consequently, his motion is denied. So it's denied, but it doesn't mean the judge is not going to allow extensions of time now or into the future. So I don't want anybody to get it twisted with that. This was the judge, I think, slamming the way the defense filed that motion and maybe the way they were doing business before. Because you know the judge can see prior motions, he can watch prior hearings. Maybe he's saying, that's not how we're going to play this game. Give me all the information, put it in writing so I can take time to review it, do my own research, and make a determination as to which way this should go. Azam, Peter, off topic regarding Lake and Riley. If I understand your previous video, it is the judge who determines what evidence is admissible, right? Yes. It's not only the judge making a determination of what evidence is admissible, but also the judge that's the one that's considering that evidence that he says whether or not it's admissible. Thumbs up to myself. 2-2. Don't you think that can make a judge biased? Like you said, the judge is human. Doesn't it potentially be grounds for appeal if found guilty? So no, so let me answer this question, both parts. Number one, no, it's not going to be grounds for appeal because that's the only way it can be done. That's the way the law works. In a bench trial, the judge makes both decisions, the gatekeeper and the fact finder or the decision maker. Does it make a judge biased? I don't know. That's a person by person thing. I think I would do my best, but if I saw a really damning piece of evidence that I found was irrelevant or should be limited out, that would be tough to put behind me. So we're going to see now what's going to happen with all these different motions of limine. These motions to suppress, this Frank's hearing motion. If I were going to guess based on what I know, which is not everything in this case, right? There's a lot I don't know in this case. So if the law enforcement really did lie, if they really did omit exculpatory evidence, I hope the judge does suppress the evidence. But from what I've seen so far in this case, and even some of the arguments made here, I would expect most of this is not going to get suppressed. That's what I would guess is going to happen in this case. I think most of this evidence, if not all of it, is going to go forward. Now, the hardest one for me to place is the IGG because that's a little bit different. Something I want to hear more about and hear the arguments about. I really hope that some of this gets done and fleshed out and argued in open court so we can hear what the arguments are, hear what the judge says, and why. That's really what I'm that's really what I'm hoping for to happen in the future. All right. Thank you, everybody, for joining me for the Kohberger update. If you're still interested in this case, let me know by hitting that like button. Let me know in the comments. And by the way, there's like 40% of people here right now watching this video that aren't subscribed. So take a second and please subscribe to our page. It helps us out a lot. We love to have you back on this case and other cases we may be following. The Lake and Riley trial, I think, is going to be wrapping up maybe tomorrow. So I'll hopefully be able to do a video on it tomorrow. I heard there's some Diddy stuff I'm going to check out. Let me know what you guys are watching, and I'll see if I can check it out and continue to give updates on it. But I thought so much happening in Kohberger, we'd give a little update here and kind of see what is happening. They also talked about comments that he made post-arrest. They want to suppress those. What comments are they? We heard some reports. Did you arrest anybody else? I don't know if it's that or something else. There's so many different things in this case happening under seal that we don't know, that I think we could really be shocked when the trial happens. Hopefully there are cameras in the trial because you never know what's going to happen. Peter, I just want you to know I appreciate you. Thank you so much, Megan. I appreciate that. I got to be honest, it's like, it's kind of wild. Some of the stuff that happens online. So it's very nice to get a comment like this. Thank you very much. Breaking. Peter is filing a case against the chat. No, I would never. I would defend the chat. Defend your honor. All right. That's all I got, folks. Thank you so much for joining me. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.